Many clients treat the conditional order as the finish line. They assume that once they have that document, the marriage or civil partnership is over. But the union only legally ends when the court grants a final order. Until then, the parties remain legally tied. This timeline represents the mandatory period between that initial court acknowledgement and permanent legal dissolution. The court enforces a specific cooling-off period before this final stage can be reached. The requirements for navigating this gap change based on whether the application is sole or joint. Failing to follow this statutory timeline can delay dissolution, complicating the legal status of both parties. This diagram shows the absolute minimum wait time required before a practitioner can apply for a final order: 6 weeks and 1 day. The math here is precise. An application submitted at exactly 6 weeks is premature. The process must be initiated from the start of the following day. Filing during this initial period is known as an AIN-time application. This standard application window lasts for exactly 12 months from the date the conditional order was granted. This 12-month period establishes the window for standard action, after which the application process becomes more complex. On the joint application path, the court expects both parties to cooperate to move the case to its conclusion. If one partner submits their request but the other fails to respond to the paperwork, the entire joint process stalls. To prevent one party from blocking the process, the digital court system triggers a 14-day timer. If the timer hits 0 without a response from the second party, the first applicant can choose to switch to a sole application. This mechanism ensures that an uncooperative spouse cannot stop the divorce simply by ignoring the system. Sole applications involve a different set of procedural branches, as one party takes the lead in finalizing the dissolution. To protect the other party, Section 10 of the Matrimonial Causes Act 1973 provides a specific defense for the respondent. Under Section 10, the respondent can block the final order if they can show the court that the divorce would result in unreasonable financial hardship. The court will not finalize the order until it is satisfied that the financial arrangements are fair. There is also a safeguard for when the sole applicant simply stops moving forward. If the initial 12-month window expires without a final order, a new arrow appears on the timeline. 3 months after the applicant's window closes, the respondent gains the legal right to take control and apply for the final order themselves. These rules ensure that respondents are protected from both financial prejudice and the risk of being left in legal limbo by an inactive applicant. Let's test these timelines. Consider this scenario. If the joint application stalls on April 15th, what is the earliest date the process can be salvaged? Because applicant A submitted their part on April 15th, the 14-day rule applies, allowing a switch to a sole application on April 29th. Once the cooling-off period ends and any financial objections are resolved, the court officially pronounces the final order. This pronouncement is the specific moment the marriage or civil partnership is legally dissolved. This summary maps the essential procedural triggers we have examined, from minimum wait times to respondent fail-safes. Managing these precise statutory deadlines is the only way a practitioner can ensure a client reaches a binding final order.